Mr. Speaker, I further beg to give notice that the next meeting of the House I will move. Be it resolved that the Judiciary Salaries Order 2017 under the Judiciary Act, which was laid on the table of the House on the 20th day of June 2017, be referred to the Regulations Committee of the House Representatives for consideration and report. Mr. Speaker, I further beg to give notice that at a later stage today, I will move for the suspension of standing orders to enable me to take this motion.
Questions and answers to question.
Mr. Speaker, today the Minister of Science, Energy and Technology will give answer to question 5 and question 7. The Minister of Local Government will give answer to question number 10 on the 26th day of June 2017, and the Prime Minister will give answers to question number 3 on the 27th day of June 2017.
But Mr. Speaker, I know that the House Leader had given a commitment and he's seeking to fulfill the commitment from last week. But I think we need to have an understanding, especially when questions are overdue, to ensure that the questioner is aware when the question will be answered. Because I might have been away today and the Minister of Energy answers my question, and I think that is unfair. It is unreasonable, especially because, again, permission ought to be received from the questioner when the extension is being sought, and it really has to be sought. So Mr. Speaker, if I could get a commitment from the acting House Leader that in relation to overdue questions, that prior to the sitting of Parliament, the questioner will be advised before being taken by surprise on the floor.
Mr. Speaker, we went through this last week and we had that understanding. And secondly, Mr. Speaker, normally when the agenda to the House is done, it's normally sent to the Leader of Opposition Business, and it includes in it the question to be answered. But I give my undertaking that in the future we'll follow that procedure, the proper procedure then. The procedure laid out and will be followed. I didn't ask no question, you know.
Okay. Can the Minister of Energy answer questions 3 and 4 in my name?
Minister Wheatley.
Thank you very much, Mr. Speaker. Question number 5 on the order paper. Question 1. Will the Minister state, 1, what is the Energy Council? 2, who are the members of the Energy Council? 3, whether or not he has met with the Energy Council since assuming office? Answer. The Jamaica Energy Council is an advisory body established by Cabinet in March 2012 geared towards facilitating broad-based consultation among key energy sector stakeholders and expanding the implementation of the National Energy Policy 2009-2030. Answer to Section 2. The 23-member JEC board comprises a complement of private and public sector representation. These include representatives from the Office of the Prime Minister, as well as the Ministries of Finance and Planning, Agriculture and Fisheries, Youth and Culture, Transport, Works and Housing, Local Government and Community Development, Water, Land, Environment and Climate Change, and Industry, Investment and Commerce. There is also provision for representation by the opposition. The membership also includes representatives of the PIOJ, Jamaica Promotions Corporation, Development Bank of Jamaica, Jamaica Public Service Company, Jamaica Chamber of Commerce, American Chamber of Commerce, Private Sector Organization of Jamaica, the Small Business Association of Jamaica, Jamaica Institute of Architects, and academia, among others. The Secretariat that supports the functions of the JEC comprises representatives of the Ministry with responsibility for energy and the Petroleum Corporation of Jamaica to support the Council's function. Answer to part 3 of question 1. There has been no meeting of the JEC since February of 2016. Question 2. If the answer to part 3 above is in the negative, would the minister state why there has been no meeting? Answer. The membership has been under review as well as the format and effectiveness of the JEC meetings. More particularly, the intention is to have more focused discussions on specific energy-related issues with the relevant stakeholders, with a view to assisting with the implementation of policy. Going forward, the JEC will also focus on public awareness in respect of energy policy initiatives that are being pursued by the government of Jamaica. In the interim, there have been smaller, more focused meetings with key stakeholders on the most pressing energy issues that have arisen, and this has proven to be an effective means of identifying solutions.
Mr. Speaker, let me thank the Minister for the truthfulness in the answers because
No, he finds it so unusual.
well, the minister is no. Shock in a sense because the minister has admitted that since the elections of February 2016, the Energy Council has not met. And that for me is really a shame. Because as the minister has put it, the Energy Council was formed in March 2012. And I want to just press the minister a moment here in relation to the role of the Energy Council, because it is more than just what is inserted. The minister, are you aware that the Energy Council was established to implement the energy policy?
I'm aware that in a former dispensation that they rely to some extent on the Energy Council to assist with the implementation, but not solely responsible with the implementation of the national energy policy. In fact, we have continued discussions, even though in smaller groups, as I mentioned earlier, as to the implementation of policy. But I'm sure that the member appreciates the fact that as it relates to the level of the policy and even the very format of this JEC as was proposed in 2012, that we want to ensure that the composition not only covers a wide array of persons or players in the industry, but ensure that it is effective. And I'm sure the member will appreciate that based on the fact that the outcomes from the previous JEC let me say, member, that I'm currently looking at the composition of the new JEC, and of course, a JEC that will be more focused and deliberate as relates to the implementation of national energy policy.
So is it that you intend to resume the functioning of the JEC, and can you indicate a specific timetable for the resumption of the activities of the JEC?
In short order, and of course, you will be given an invitation to participate. Move to question 7. You guys don't have to pay attention. Question 7. Come. No. Question number 1. Will the minister please state whether or not net billing has resumed? Answer, yes, net billing has resumed. Question number 2. Come on, stop your eyes. If the answer to 1 above is in the affirmative, would the minister please state A, when the resumption began, B, how many such licenses have been awarded, C, for what volume of electricity? Answer, A, following the cessation of net billing, the net billing pilot program on Monday, April 11, 2015, the Office of Utilities Regulation, OUR, resumed accepting applications for net billing under similar terms as the previously concluded net billing pilot program until details of a permanent program were finalized. As of January 1st, 2017, the ministry with responsibility for energy assumed the administration of the net billing license. The ministry with responsibility for energy also established the Energy Licensing Office, which is the entry point for applications for net billing, auxiliary connections, and electric power wheeling license. B, from April 11, 2016, when the OUR resumed the net billing pilot program to present, a total of 239 licenses have been issued. C, from April 11, 2016 to present, the total capacity that has been allocated by way of net billing license is 5.421 megawatts. Question 3. Would the minister please state how many net billing licenses were awarded up to January 2016? A total of 570 net billing licenses were issued from the commencement of the net billing pilot program to January 2016. Question 4. Would the minister please state if there is a processing charge for a new billing license? Yes, in accordance with the Electricity Act of 2015, applications for net billing license are charged a non-refundable processing fee of $15,000. This fee compensates the government of Jamaica for processing and verifying the information that is provided by the applicant, which includes ensuring ownership of the premises and checking the actual amount of electricity that can be exported to the grid based on the inverters being utilized by the applicant's system. Question 5. Would the minister please state whether or not the legislative framework is in place for power wheeling? Answer. The requisite legislative framework is in place, which will be supplemented by discrete regulations for electric power wheeling pursuant to the Electricity Act of 2015. The existing legislative framework comprises 1, the Electricity Act of 2015, which outlines the basis for granting all electricity licenses, including electric power wheeling license. That act has provided a framework for power wheeling by prescribing a definition for electric power wheeling and by making provision for the minister to grant the relevant license. And 2, the Electricity license 2016, that is the JPS license, in condition 12, where it requires the company to implement the electric power wheeling service on terms approved by the Office of Utilities Regulation. In respect of the electric power wheeling regulations, the Ministry with responsibility for energy is awaiting final revisions to be incorporated by the Chief Parliamentary Council so that the regulations can be tabled in Parliament. Will the Minister please state, question 5, would the Minister please state whether or not any license have been granted for power wheeling? Answer. Having received no applications, no license have been granted for electric power wheeling. Question 7. Would the Minister please indicate the respective rules for A, the Minister, B, the Office of Utilities Regulation, and the Jamaica Public Service Company in the process of granting a power wheeling license? Answer. The Minister is responsible for the electric power wheeling license. Under the Electricity Act of 2015, a license required where a self-generator is desirous of connecting to the grid for electric power wheeling. The Minister with responsibility for energy is responsible for granting all energy-related licenses, including that for electric power wheeling. B, the electric power wheeling contract is negotiated between the JPS and the wheeler. This contract would have standardized terms, including the use of system charge. The OUR sets the use of the system charge. Section 18.7 of the Electricity Act 2015 stipulates that the Office of Utilities Regulation is to implement a rate for electric power wheeling by March 27, 2016. This is mirrored in condition 12.2 of the Electricity Act of 2016, which states that the use of system charge shall be determined by the OUR, which may be informed by a cost of service study done by the JPS. The OUR has chosen to have the rate informed by a cost of service study prepared by the JPS. As the cost of service study has not been forthcoming, the OUR has recently indicated that it will implement an interim rate of electric power wheeling. The Ministry with responsibility for energy has requested a date by which the interim rate will be introduced. The OUR also regulates the electricity sector generally. The JPS implements a wheeling service. The Electricity Act 2015 and the Electricity License 2016 requires the JPS to implement an electric power wheeling service in accordance with such terms and conditions as are approved by the OUR. Accordingly, the JPS is responsible for the execution of standard contracts and commissioning the electric power wheeling facility and providing the commissioning report to the self-generator, the ministry, and the OUR.
Thank you, Minister. There are some follow-up questions in relation to both net billing and power wheeling. In relation to net billing, you mentioned that so far there's an amount of 5.421 megawatts of electricity that has been approved, licenses have been approved. Is there a limit that the ministry has recommended? And if so, what is that limit? That is one. You mentioned that the charge processing fee is $15,000. Is that in relation to residential alone, or it applies as well to business?
I believe the limit for net billing is 12 megawatts. And I can double check the actual figure. I think it's somewhere in the region of 12 megawatts in total. And the non-refundable processing fee of $15,000. I'm sure it is for residential. It is for residential customers. Of course, commercial customers, the application fee is I think, in the region of $50,000.
All right, so it is clear that roughly half, well, less than half of the amount allocated has been taken up so far. So the ministry really has to engage the public in educating them of this facility. I'd like to turn to the matter of wheeling, because the answers given do not provide for me the current status of power wheeling. You're saying that power wheeling, though there is the law, that power wheeling is not yet effected. And I am not too clear as to why.
First and foremost, we have not received any application for power wheeling. So that, in a sense, would not allow me to further comment. Notwithstanding that, though, the Act speaks to power wheeling. The license that was given to JPS in 2016 also speaks to accommodating power wheeling. As I stated earlier, the OUR is responsible for setting the use of system charge, which is not a bone of contention, but an outstanding matter. And so a cost of study service was supposed to have been done by the JPS to inform the OUR as to how best to set that system charge fee. Seeing that was not forthcoming from the JPS, in fact, I had written to the OUR asking for an update on the matter and prompted them to take action in a sense, because we recognize that the time had passed for the implementation of a rate to assist with the whole process of electric power wheeling. And that date was March 27th of last year. So the OUR took a decision then that seeing that it was not forthcoming from JPS, that they would set an interim rate for power electric wheeling. However, member, again, let me remind you that we have not gotten any application as relates to power wheeling to date.
Well, I know that you genuinely believe so, but I am aware that there is an application in-house, and there are others to follow, but nobody's going to apply if the framework isn't finalized. And you haven't given us a time frame as to when the initial rate, that the interim rate, that the OUR is going to be instituting, be put in place. Because if you are going to wait for the JPS to do that, it is not in their best interest to do so. So probably you could indicate to us, when will we get that interim rate, and thereby enabling persons to rush to apply for power wheeling?
I await the OUR to give me an update as to when the rate, they will be in a position to give us the actual rate, and I will furnish you as soon as possible with a definitive date. I'll check on that and report back to your member.
Well done, Phil. Well done. Well done. Next week, you come back. Motions that may be made at the commencement of public business requiring notice. Motions for leave to introduce bills. Presentation of bills without leave of the House first obtained. Public business.
Mr. Speaker, on the public business, the Minister of Justice will commence debate on the bill shortly entitled the Criminal Justice Administration Amendment Act 2017, and will also commence debate on the bill shortly entitled the Indictments Amendment Act 2017.
Mr. Chuck.
Thank you, Mr. Speaker. Mr. Speaker, I'm very pleased to present to the House of Representatives the Criminal Justice Administration Amendment Bill 2017 and the Indictments Amendment Bill 2017. These bills, Mr. Speaker, are aimed at, among other things, enabling, one, the trial of lesser offenses together with the offenses of murder other than capital murder on a single indictment by a judge sitting with a jury. Two, the trial of joinable offenses, including those triable by a Supreme Court judge with or without a jury, together on an indictment, single indictment, by a judge sitting with a jury. Three, the trial of joinable offenses, whether triable on indictment or summarily, together on a single indictment in the Supreme Court. Four, the trial of joinable offenses arising on the different enactments which are triable by a judge sitting alone, together with on a single indictment in the Supreme Court by a judge sitting alone. And five, the courts, at the conclusion of a criminal trial, if there's clear evidence that the victim has suffered loss as a result of the crime inflicted by the convicted offender, to make an order that the convicted offender makes restitution for the victim's loss. Mr. Speaker, earlier this year, Cabinet reviewed a submission to give effect to the above-mentioned amendments. Upon Cabinet's approval, the bills were drafted by the Office of the Parliamentary Counsel and submitted to the Legislation Committee for review. The committee approved the bills for submission to the Houses of Parliament. Mr. Speaker, the current state of the law as it relates to how certain criminal matters progress through the courts is an impediment to the timely delivery of justice. The stratification of criminal offenses creates the phenomenon we refer to as jurisdictional silos, where offenses are tried in different levels of the courts based on their nature and prescribed penalties, etc. This, Mr. Speaker, prevents the courts from trying all offenses that may arise on the facts before the courts, notwithstanding that the allegations may disclose that all offenses occurred substantially at the same time in the same transactions. The effect of this practice is that oftentimes, Mr. Speaker, offenses arising from the same factual matrix are tried independently in separate proceedings, and thereby creating unnecessary inefficiencies in the criminal justice system. Mr. Speaker, this jurisdictional silo was created by legislation and the classification of criminal offenses as either indictable or summarily. Indictable offenses are governed by the Indictments Act and are so designated because of the originating document, that is, the document used to charge the offender. Indictable offenses are generally tried in the circuit court, with some exceptions as stated by the Judicature Parish Courts Act. Under this Act, Mr. Speaker, certain specified indictable offenses are triable in the parish courts. Mr. Speaker, summary offenses, on the other hand, are triable in the parish courts or, in the case of very minor offenses, the petty sessions courts. There are exceptional offenses, Mr. Speaker, that can be tried either on an indictment in the Supreme Court or summarily in the parish courts. There are also a few other offenses, Mr. Speaker, that are triable either way, in the parish court, on an indictment, or summarily. Mr. Speaker, by Rule 3 of the Schedule to the Indictments Act, charges for any offenses, whether felonies or misdemeanors, may be joined in the same indictment if those charges are a part of a series of offenses of the same or similar character and may be tried together. It is to be noted, however, Mr. Speaker, that offences under the Gun Court Act may be tried by different procedures depending on the gravity of the offence. Some offences are triable by jury, while some by judge alone. For summary offences, Mr. Speaker, Section 22 of the Criminal Justice Administration Act sets out, amongst other things, that 2 or more offences arising out of acts so connected as to form the same transaction can be tried together. Mr. Speaker, notwithstanding these provisions of the Indictments Act and the Criminal Justice Administration Act, both acts are silent on whether summary or indictable offences can be tried together in the same proceedings. Further, Mr. Speaker, the Court of Appeal has declared that a joint trial of summary and indictable offences is a nullity. Additionally, Mr. Speaker, the courts have ruled that matters tried under the special statutory summary jurisdiction of the parish courts cannot be tried jointly with matters triable under the petty sessions jurisdiction of that court. Mr. Speaker, you can appreciate the difficulties faced by the prosecution when an accused is charged with both indictable and summary offences arising out of the same facts. The prosecutor then becomes burdened by a need to decide which offence is to be tried first and which court has jurisdiction. By extension, Mr. Speaker, the fate of the accused is delayed. You may have, Mr. Speaker, an accused who committed a series of offences under the same circumstances and was tried for one offence in one court and is awaiting trial for the other offence in another court because of the classification of the offences. This system, Mr. Speaker, only serves to delay the trials of accused persons and clog the justice system. Mr. Speaker, if we are serious about improving our justice system, we must seize every opportunity to make the changes necessary to contribute to the desired improvements. These amendments are low-hanging fruits, and everyone, particularly the accused persons, stand to benefit. Mr. Speaker, let me hasten to point out that the amendments being tabled will also benefit victims of crimes through the payment of restitution by convicted persons to their victims. Currently, Mr. Speaker, where the victim of a crime suffered loss and or damage as a result of the criminal acts of the accused, the victim has to initiate separate legal proceedings in the civil court to claim compensation. This can result, Mr. Speaker, in further delays, inefficient use of the court's resources, and injustice to the victim. In recognition of this, Mr. Speaker, the government has in recent times sought to remedy this by including provisions in legislation to allow the court to make orders at the end of the criminal trial for restitution to be made to the victims by the convicted person. Section 17 of the Law Reform, Fraudulent Transaction, Special Provisions Act 2013, and Section 6 of the Trafficking in Persons, Prevention, Suppression, and Punishment Act, as amended in 2013, are examples. These provisions, however, are specific only to the offences created under the respective statutes, and there remains a void to be filled generally. Mr. Speaker, this amendment to the Criminal Justice Administration Act will remedy this lacuna. A judge in a criminal trial will be empowered to order generally that a convicted person makes restitution to the victim of a crime. This restitution, Mr. Speaker, will serve to compensate the victim for actual losses and is not intended to abridge the victim's rights to sue the convicted person in the civil courts for damages. It is envisioned that with the award of losses, the victim will be placed at a minimum in the position he would have been in had the crime not been committed. These amendments, Mr. Speaker, will be a boon to the justice system. Mr. Speaker, I will now highlight the main features of the bills. Under the Indictments Amendment Act 2017, Clause 2, this clause amends Rule 3 of the schedule to the Indictments Act to allow for the joinder of offenses that are so connected to form part of the same transaction despite their classification. Mr. Speaker, the prosecution will have the discretion to decide whether to join any offenses, but the court will still have the power to order that offenses are tried separately if, 1, there's a risk of injustice, and 2, the administration of justice is better served by the separation. Mr. Speaker, as it relates to murder, the amendment allows non-capital murder to be tried together with lesser offenses on a single indictment by a judge sitting with a jury. Further, where the joined offenses are a mix of offenses which are tried by a judge sitting alone and a judge sitting with jury, the joint offenses may now be tried together on a single indictment by a judge sitting with a jury. Mr. Speaker, joint offenses tried by a judge of the Supreme Court, whether with or without a jury, and offenses tried by the parish court may now be tried together on a single indictment in the Supreme Court. Where the joint offenses arise under different pieces of legislation and are each tried by a judge alone, they may be tried on a single indictment in the Supreme Court by a judge sitting alone. Clause 3 consequentially amends Section 31 of the Jury Act to include joined offenses for which a sentence of death may be imposed. Death. Clause 2, Mr. Speaker, under the Criminal Justice Administration Amendment Act 2017. This clause allows the joinder of offenses tried by the parish courts, despite their classification as indictable, summary, or petty sessions, as long as they are founded on the same facts, arise out of a single act or series of acts, form part of a series of offenses of the same or similar character, or are so connected to form part of the same transaction that they can be tried, joined together at trial. Similar to the position of the Supreme Court, the parish judge will be able to make an order for separate trials. Additionally, Mr. Speaker, appeals for joined offenses at the parish court shall be heard by the Court of Appeal. Clause 3 under this Act, Mr. Speaker, empowers a judge to order a person convicted of any criminal offense to make restitution to the victim of his crime, once there is sufficient evidence that the commission of the crime caused the victim to suffer loss. Such restitution, Mr. Speaker, may mean that the convicted person returns property to the victim, pay for the cost of the property, return money with interest, pay for medical bills, lost income, attorney's fees, etc. This restitution, Mr. Speaker, may be enforced by the victim or the prosecution on behalf of the victim. Clause 4, Mr. Speaker, amends Section 5 of the Gun Court Act to allow for the joinder of offenses under that act with other offenses, as long as those other offenses are tried by jury. Mr. Speaker, this ends the clause-by-clause summary of the bills before you. Shortly, Mr. Speaker, I will commend the bills to other members of the House, which after the suspension today, next week or the week after, we hope that they will be able to make their contributions. But, Mr. Speaker, improvements to the justice system is absolutely necessary. The justice system for criminal trials and civil cases is overburdened and clogged. Mr. Speaker, blame can be passed all around. It may be the judges, it may be the prosecution, it may be the defense lawyer, but the government must accept most of the blame, Mr. Speaker, for not providing the resources to have more courts, more judges, more personnel, so that cases can be tried in a timely manner. True. But in truth, Mr. Speaker, even if we provide all the judges, all the prosecutors, all the defense counsel, all the facilities, the number of cases we have in the courts will not be tried for the next 5 or 10 years. Mr. Speaker, there are over 2,000 cases to be tried this term alone in the circuit courts. In the home circuit, you have 700 and odd cases, Mr. Speaker. And with the best will in the world, if you were to try every single one of them in 10 courts, we would not finish them for the next 2 or 3 years. And more cases are coming on daily and weekly. And that is why, Mr. Speaker, the bill which was passed in this House and shortly to become law when the Governor General signs off the plea bargaining bill, the arbitration bill, and also mediation, which will be adjusted, litigants, prosecutors, defense counsel, lawyers will have to look at alternative means of settling disputes in our country. Mr. Speaker, it is natural, not abnormal, for there to be conflicts. No two people are alike. When you look at the member from Central Westmoreland, very different from me, or Eastern Westmoreland. Eastern. Every time I look at him, I see a difficulty, a conflict. Yeah. And I know, and tomorrow, and I'm drunk and you're ugly. Tomorrow I will be sober. Good one, Mr. Speaker. Shut up. Mr. Speaker, the message must go out to every corner of this country. Yes. We have to find ways and means to settle our differences. Conflicts, problems must be settled in an amicable way, without violence, without having to end up in courts, Mr. Speaker. Because when you go to court, they're not going to be settled for years. So we're appealing to litigants to please try and settle your differences. And if they have to come to court, let us use, which I will be on later on, the plea bargaining bill, mediation, arbitration, to get matters dealt with in an expeditious way. These bills, Mr. Speaker, are just a small part and will play a small part in unclogging the system, but the bigger unclogging of the system must be dealt with by other legislation. Which, having said those, Mr. Speaker, I now commend these bills to the members of the House for approval.
House Leader.
Mr. Speaker, I ask for the suspension on both bills for a further date. We can do it next week.
Those in favor? Those against? Ayes have it.
Mr. Speaker, the private member's motion number 2 and number 12 by the member from Central Kingston is not here, so we'll do it at a further date, future date. He's not present, so we'll take it at future date. Mr. Speaker, I now move for the suspension of standing orders to enable me to take the motion the Special Select Committee approved by the Law Reform Zone of Special Operations, Special Security and Community Development Measures Act 2017, notes of which I gave earlier. No, take one by one.
Those in favor? Those against? Ayes have it.
I ask that the motion be approved.
Those in favor? Those against? Ayes have it.
Mr. Speaker, further move for the suspension of standing order to enable him to take the motion, the Judiciary Salaries Order 2017, notice of which I gave earlier.
Those in favor? Those against? Ayes have it.
Mr. Speaker, I ask that the motion be approved.
Those in favor? Those against? Ayes have it.
Mr. Speaker, is not intended to do any further business for the day, so I ask that the House be, adjourned. Why don't you shut your crap? Sit down and shut up.
Mr. Speaker, look at the crime. Look at where we are.
In anyhow, Mr. Speaker, I do understand, you know. Mr. Speaker, I do understand. Empty bars make the most noise. I do understand, Mr. Speaker. Empty bars make the most noise. I ask that the House be adjourned until next week, Tuesday, when the House will take a motion to honor the former Prime Minister, the most honorable person since Miller.
Those in favor? Those in favor? Yeah, but I will take the motion. Yeah. The motion is that the House be adjourned until next Tuesday, June 27. Those in favor? Those against? Ayes have it. This House now stands adjourned.
We stay here. Stay here. We stay here and you guys.
One morning, when the police are just doing traffic duties and keeping the peace, and they don't have to worry about even their own security. Take responsibility for yourself and your surroundings and for your neighbors. Be your neighbor's keeper. Be your brother's keeper. Let's come together and create a safer and prosperous Jamaica.
A message from the Ministry of National Security.
My name is Go Williams.